Exploring AI, AI regulation, and AI security.
What is artificial intelligence? The Organization for Economic Cooperation and Development, OECD, defines an artificial intelligence, AI, is a machine-based system that, for explicit or implicit objectives, infers, from the input it receives, as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Different AI systems vary in their levels of autonomy and adaptiveness after deployment. Benefits of AI: 1. Chatbots. 2. Smart assistants. 3. E-payments. 4. Search algorithms. 5. Media streaming. 6. Smart cars. 7. Navigation apps. 8. Facial recognition. 9. Text editors. 10. Social media feeds. Why there is a need of AI regulation. 1. Ethical concerns. Ensures that AI technologies are developed and used in ways that respect fundamental human rights and values. 2. Accountability and transparency. E-regulations help establish accountability for the actions of AI systems and their developers. 3. Consumer protection. Safeguard consumers' privacy and data rights. 4. Security concerns. Securing AI systems against cyber threats, hacking, and unauthorized access to prevent potential harm or misuse. EU Artificial Intelligence Act. On Friday, December 8th, the European Union (EU) groups agreed on important rules for how artificial intelligence (AI) should be used. They spent many months talking and figuring out these rules. 1. The AI Act is a big deal globally because it shows the EU wants to be a leader in making laws to make sure AI is used in a good and responsible way. 2. This act is part of other important EU laws about digital stuff, like keeping data safe, GDPR, rules for online services, fair competition, handling data, and staying strong against cyber threats. 3. The EU Artificial Intelligence Act is setting the global standard for AI as GDPR did for data privacy. Who is concerned? 1. This act applies to Point 1. Providers putting AI systems on the market within the EU, regardless of their location. Point 2. Providers and deployers of AI systems located in a non-EU country, where the output of the AI system is used within the EU. Point 3. Deployers of AI systems located in the EU. Point 4. Importers and distributors placing AI systems on the EU market. Point 5. Product manufacturers placing products with AI systems on the EU market under their own name or trademark. 2. The AI Act will not apply to Point 1. Public authorities in non-EU countries and international organizations that have law enforcement and judicial cooperation agreements with the EU, provided that adequate safeguards are in place. Point 4. Research, testing, and development activity regarding AI systems prior to placement on the market or into service. Point 5. Free and open-source software, unless their use would classify them as a prohibited or high-risk AI system. Point 2. AI systems used for purposes outside the scope of EU lawmaking authority, such as military or defense. Point 3. AI systems specifically developed and used for the sole purpose of scientific research and discovery.
Risk-based classification. The EU AI Act introduces a risk-based classification scheme for AI applications. The main criterion is the level of risk posed by the AI application to individuals or society as a whole. The classification ranges from minimal risk to applications which are banned entirely. Exceptions to high-risk classification. An AI system will not be considered high risk if it performs a narrow procedural task with no direct safety or security implications, is meant to review or improve the quality of human output, is used to detect decision-making patterns or deviations from existing patterns, to flag inconsistencies without influencing decisions. Compliance requirements for the provider of high-risk AI. The EU AI Act lays out a range of requirements for AI systems, high risk but also limited risk, from the design, implementation, and post-market entry phases. Risk Management System, Article 9, Data and Data Governance, Article 10, Technical Documentation, Article 11, Annulment or Record Keeping, Article 12, Transparency and Provision of Information to User, Article 13, Human Oversight, Article 14, Accuracy, Robustness, and Cybersecurity, Article 15, Quality Management System, Article 17, Fundamental Rights, Impact Assessment, registering high-risk AI systems on the EU database before placing them on the market. Systems used for law enforcement, migration, asylum and border control, and critical infrastructure will be registered in a non-public section of the database. Pre-market conformity assessment. Providers are obligated to conduct a conformity assessment on the high-risk AI system before introducing it to the market. The assessment should scrutinize compliance with the specified requirements. In most instances, providers can perform a self-assessment if they adhere to procedures and methodologies aligned with EU-approved technical standards, harmonized standards, with the application of these standards leading to a presumption of conformity. However, a third-party conformity assessment by an accredited body becomes mandatory under certain circumstances, including if the AI system is a component of a safety component subject to third-party assessment according to sectoral regulations, if it is part of a biometric identification system, or if harmonized standards are not employed. Post-market obligations. After a high-risk AI system has been introduced to the market, providers are obligated to ensure ongoing safe performance and conformity throughout the system's lifecycle. These obligations encompass the following: retaining logs generated by high-risk systems within their control for a minimum of 6 months, promptly implementing corrective actions for non-conforming systems already in the market and informing other operators in the value chain about these non-conforming systems, cooperating with national competent authorities or the AI office. Refer to the relevant section below by sharing all necessary information and documentation to demonstrate conformity upon receiving a reasonable request. Continuously monitoring the performance and safety of AI systems throughout their lifespan and actively assessing ongoing compliance with the AI Act. Reporting serious incidents and malfunctions leading to violations of fundamental rights to the appropriate authorities. Undergoing new conformity assessments for significant modifications, e.g., changes to a system's intended purpose or alterations affecting regulatory compliance. This requirement applies whether the modifications are implemented by the original provider or any third party. For AI systems considered to have limited or minimal risk, it is crucial to verify whether the initial risk classification still holds true after any changes. Obligations for deployers, importers, and distributors. Responsibilities of deployers of high-risk AI systems encompass conducting a fundamental rights impact assessment, FRIA, before deploying the AI system, a requirement applicable to both public entities and private entities delivering services of general interest, such as banks, insurers, hospitals, and schools employing high-risk systems. Establishing human oversight by individuals with appropriate training and competence. Ensuring the relevance of input data to the system's intended use. Temporarily halting the system's use if it poses a national-level risk. Reporting any serious incidents to the AI system provider. Retaining automatically generated system logs, adhering to pertinent registration requirements when the user is a public authority, meeting GDPR obligations for conducting a data protection impact assessment, confirming the AI system's compliance with the AI Act and providing evidence of all relevant documentation, notifying individuals who may be subject to the use of high-risk AI. Obligations for minimal risk system. Providers are required to design and develop systems in a manner that ensures individuals are aware they are interacting with an AI system from the beginning, as seen in the case of chatbots. Deployers, on the other hand, must inform individuals and seek their consent when utilizing permitted emotion recognition or biometric categorization systems. Clearly disclose and label instances where visual or audio content, particularly deepfake content, has been manipulated by AI. Obligations for minimal risk system. General-purpose AI system means an AI system that is able to perform generally applicable functions such as image-speech recognition, audio-video generation, pattern detection, question answering, translation, etc., and is able to have multiple intended and unintended purposes. Providers of all general-purpose AI GPI models are obligated to maintain and keep technical documentation up to date, provide information to downstream providers aiming to integrate the GPAI model into their AI systems, adhere to EU copyright law, disseminate comprehensive summaries of the content used for training. Moreover, providers of high-impact GPAI models that pose a systemic risk must Conduct model evaluations, evaluate and address systemic risks, document and report any serious incidents and the corresponding corrective measures to the European Commission, implement adversarial training of the model, commonly known as red teaming, ensure the presence of sufficient cybersecurity and physical protections, document and report the estimated energy consumption of the model. How business can prepare now for the entry into force of, while waiting for the AI Act to be formally adopted by May 2024 and to become fully applicable, organizations using or planning to use AI systems should start addressing impacts by mapping their processes and assessing the level of compliance of their AI systems with the new rules. The AI Act is the first formal legislation to begin to fill in the gaps of ethical and regulatory principles to which organizations must adhere when deploying AI. Compile an inventory of all AI systems your organization has developed or deployed, evaluating whether any fall under the purview of the AI Act. Assess and categorize the AI systems within the Act's scope to ascertain their risk classification, identifying the corresponding compliance requirements. Understand your organization's position in relevant AI value chains, recognizing associated compliance obligations and implementing compliance across functions responsible for AI systems throughout their lifecycle. Consider additional aspects such as potential questions, risks, e.g., interactions with other EU or non-EU regulations, including data privacy regulations and opportunities, e.g., access to AI Act sandboxes for innovators, small and medium enterprises, and others that the AI Act may present to your organization's operations and strategy. Formulate and implement a plan to ensure the establishment of appropriate accountability and governance frameworks, risk management and control systems, quality management, monitoring, and documentation when the Act takes effect. AI risk management, identify risks and minimize negative impacts on organization, map risks to organizational priorities and taxonomies, deploy and track mitigation strategies and residual risks, fairness, transparency, and security, implementing an AI governance strategy. Beyond the AI Act. Other standards and frameworks supporting ethical use of AI: ISO 42001, 2023 Information Technology Artificial Intelligence Management System, ISO 23894, 2023 Artificial Intelligence Guidance on Risk Management, ISO FDIS 5338 Artificial Intelligence AI System Lifecycle Processes, ISO 24028, 2020 Artificial Intelligence Overview of Trustworthiness in Artificial Intelligence, ISO TR 24027, 2021 Artificial Intelligence Bias in AI Systems and AI-Aided Decision-Making, ISO TR 24360, 2022 Artificial Intelligence Overview of Ethical and Societal Concerns. We help you build AI in line with these standards. CDAI Principle OWASPL My Security and Governance Checklist, ISO 42001, 2023 Information Technology Artificial Intelligence Management System.